Hello, my name is Scott Nicoll. I'm a partner with the law firm of Hamilton, Duncan, Armstrong and Stewart, and I'm also the lawyer for the Massage Therapists Association of British Columbia. The association has asked me to do a brief video for its membership to highlight the points in the Personal Information and Protection of Privacy Act that anyone working in a massage therapist clinic needs to know when they deal with the personal information of patients, employees, co-workers, or anyone else that they may come into contact with. At the outset, I think it's important to talk about the definitions of the terms we're going to be using during the video presentation this morning. First off, the personal information means any information that would allow someone else to identify an individual. Now, examples of that information include people's names, their address, their telephone number, an email address, a social insurance number, their birth date, the income they earn, even the number of dependents they have. In some circumstances can lead to someone being able to identify someone depending on what other information they may already have. Their employment history, attendance records, and obviously that specifically relates to both patients and employees in your context. Banking details, if you happen to have a copy of an employee's resume, any of that information under the Personal Information Protection of Privacy Act is considered personal information. And again, those are just examples. The important part that you need to understand is any information you have that may allow someone else to identify that individual, that's personal information and you need to protect it. Now, for those of you that are employers, employee personal information that you're entitled to gather includes any personal information that's required to manage, to recruit, or to terminate an employment relationship. And that includes the kinds of definition of personal information we talked about earlier. You're entitled to collect that information, but the same provisions apply to managing that information as it does to your patient information. The responsibilities are the same, and you need to make sure that that information is protected and cared for in the same manner and given the same care that you give to patient information. The same provisions apply to it under the statute. Now, there is a form of employee information that is expressly actually not protected by the statute, and that's business contact information. And that includes the person's position at the clinic, their job title, the fact that if their name is publicly known as an employee of the clinic, their name. If the information is publicly provided as part of the business contact or business process of the clinic, that information is not protected and it can be disclosed without their permission. The other kind of information that's also not protected by the Act is something called work product information. And work product information is essentially information that the employees or the clinic provides or produces in their capacity as a business or an organization. If there's papers authored by that individual that provide background on that individual, that work product information is not protected by the Act and can be disclosed. Now, when you're collecting personal information, either from patients or employees or anyone else, you should do so in writing, and the form that you should have them sign is your personal privacy policy. The privacy policy is a written document that we encourage you to have and encourage everyone who provides you with personal information to execute and acknowledge that they've read it and understand how you're going to protect their information. And for a copy of a privacy policy, go to the association website or contact the association office and they can help you get one if you don't have one. You are required to have one, and so it is something that you should do if you haven't done already. If you're an employee and you are joining a clinic or some other scenario, you should, if you're providing your personal information to anyone in any capacity, you should ask to see their privacy policy. It is your personal information. The statute enables you to know when and how that information is going to be used, and in fact, how it has been used, and a copy of that privacy policy you should have in your file at home. One of the key points about collecting personal information and privacy, and for those of you who have attended the last AGM of the association, we made this point when dealing with workers' compensation files in particular, is the information needs to be collected whenever possible directly from the individual concerned. It's not permissible to phone someone up and ask them about an individual to collect their personal privacy unless and except the individual that you're collecting about is unreachable. If there's no way in which you can collect that information about that individual before providing services, then under those circumstances, it can be permissible to collect that information from a third party. Now, there are circumstances if you are a clinic owner or, for that matter, an employee and you're asked to disclose information on behalf of the clinic under which consent isn't needed to either collect or use or disclose the information. And the most obvious one in your context would be if there's a medical emergency. If consent cannot be provided in a timely way and the individual's best interests are jeopardized by you not providing that information in your estimation, the Act says you may provide that information. However, if the situation is something less than a medical emergency, and if you're not sure whether it really falls under the category of an emergency, again, I encourage you, look at the guide, phone the association office, seek some further advice. But if it's clear, if it's an emergency, you may disclose the information without their consent. You may collect the information without their consent. You may use it without their consent. There's a second instance in which the Act specifically provides for the disclosure of personal information. And while this typically won't come up in the scenario involved in most massage therapy clinics, in the event that you are contacted, for instance, by the police with respect to an investigation that may relate to an individual that's ongoing, under those circumstances, you are also not required to disclose that information under certain circumstances. This video isn't the appropriate venue to go into the details of what would be an appropriate circumstance. However, if you're contacted by some sort of government organization asking for the disclosure of personal information without the consent of the individual it relates to, you should first contact the association, and if the association can't assist, contact your lawyer. It's important that you don't disclose the information until you're confident that it fits within that exception. If the personal information is also available from other publicly available government sources, the Act also permits that information to be disclosed. So if, for instance, there's personal information about an individual that's readily available to the public from another source that government provides, under that circumstance, you can disclose it. However, when in doubt, don't. And the last situation in which you're authorized to disclose personal information without the authority of the individual concerned is the catch-all one, which is if it's otherwise provided by law. If there's a court order that you're served with requiring you to disclose personal information about another individual, then you are required to comply with the court order. If you have any questions or concerns about it, obviously you want to contact a lawyer first before doing so. But assuming that the order is valid and was properly obtained, you are authorized to disclose it under the statute. There is a further important requirement that you need to be aware of when you're collecting patient or employee personal information. And it seems obvious, but it bears reminding nonetheless. You have to get it right. Personal information needs to be, you need to take all reasonable steps to make sure that the personal information you collect is accurate. If it's not accurate, I'll get to that in a few minutes, there is an obligation you have to correct it. However, it's important that you understand from the outset that you put processes and guidelines in place to ensure that the personal information you are collecting, and this is and it applies to you whether you're an employee or a clinic owner, that it's collected accurately and properly. And if you fail to collect it accurately and then you disclose it to others, and that individual suffers some harm as a result of disclosing incorrect personal information, there are sanctions both under the statute and elsewhere in the law that could become very uncomfortable. Now, if after you've received a request for a copy of the personal information on file from an employee or a patient or anyone else, and they send you a request to correct the personal information in your file, you have two options. One, if you believe that the information reasonably should be corrected, you can make the correction, and then you need to send out that correction to anyone else that you've shared that personal information with in the past. Alternatively, your second choice is, if in your view the personal information doesn't need to be corrected or shouldn't be corrected for any reason, then you can choose not to. However, in that circumstance, you should make an annotation in your notes with respect to the request was made and the reason why you declined to do so. Now, one of the fundamental premises of the Personal Information and Protection of Privacy Act is, and this is one that's well known to most people, is that the information has to be protected. If you're in the possession of personal information relating to a patient, an employee, or anyone else, you have to take all possible reasonable steps within your control to protect that information. You have to protect that information from being accessed by unauthorized people. You have to protect that information from being disposed of inappropriately. You have to protect that information from being stored in places where others may access it electronically. And that specifically relates to servers in the United States that may be accessible to U.S. authorities. Our provisions for those of you doing workers' compensation work specifically prohibit that. The Act doesn't specifically prohibit it, but the workers' compensation contract does. But generally speaking, you have to take all reasonable steps. So, for instance, the records need to be kept under lock and key. The records should not be left on your desk at the end of the evening. The records should not be left in the reception area where other patients or other, if you happen to share an office situation where other practitioners who aren't part of your practice or under your authority or direction have access to the records. The records, if they're disposed of, should be shredded on your premises, and you should make sure that you understand that the disposal is done properly. The well-known example, unfortunately, of medical records in British Columbia showing up in dumpsters is something you want to avoid at all costs and is a clear violation of the statute. So protection is one of the fundamental cornerstones of the statute, and you need to take all necessary precautions to ensure that it's done. That includes making sure that all of your employees have watched this video. That includes making sure that all of your employees understand how their information and personal information can be used. Individuals who have shared their personal information with you are entitled to know from you how you have used their personal information. This includes patients, employees, or anyone else that provided you with that personal information. So, it's important that you keep good records with respect to how that personal information has been used. It's important that you understand who that information has been disclosed to, and it's important that the information that you've collected was accurate. If for any reason you don't have those records, you need to have a system in place as to how those records were disposed of and when, and so that you can account to that individual as to how that information was dealt with. If you get a request for the disclosure of how someone's personal information has been used, you have to respond to that request within 30 days. If you don't respond to that request within 30 days, you can expect a phone call from the Privacy Commissioner's office asking you why you haven't. The other thing you need to be aware of is there are prohibitions with respect to the disclosure of certain kinds of personal information to certain people whose personal information it actually is. And the most obvious one, and the one that you would face most often, would be if by disclosing someone's personal information to them, you would endanger them either physically or psychologically, mentally, then you are within your rights to refuse that request. If you do so, however, I would strongly encourage you to do so after you have received the advice of a lawyer with respect to the appropriateness of refusing that request under the statute. That's not the kind of decision that you should be making without that kind of advice. The other circumstance under which you may face a quandary as to whether to disclose personal information or not is if, in your opinion, the disclosure of that personal information to the individual that it relates to would endanger someone else. And you can, without too much imagination, imagine circumstances in which if there's someone's personal information is disclosed to them that in domestic dispute situations results in your expectation of danger to someone else, that's a situation when, again, I would strongly encourage you to seek legal advice. Don't disclose the information until you've got the legal advice, and then follow the legal advice once you've got it. The other situation in which you should be aware of your ability to refuse the disclosure of personal information is if, in some manner, shape, or form, the disclosure of that personal information to the individual that it relates to would result in the harm of your or another competitive position of another business organization. If you happen to be a clinic owner and the disclosure of personal information would, in your view, harm your competitive business position, you are entitled to refuse to disclose that personal information to the individual it relates to. Again, this is obviously a situation in which you would want to seek competent legal advice before standing on these grounds, as you can be sure that you will be receiving inquiries from the Privacy Commissioner should you do so. It goes without saying that if you're requested to provide personal information about a patient or an employee, that request should come in writing, and it should come with, provided it doesn't fit with under some of the exceptions we've talked about above, it should have the patient's or employee's written permission on the face of the document. And you shouldn't accept a photocopy, you should demand to see the original. It's important that you take this step to secure, as part of satisfying most privacy policies, and chances are that the provision that you will have will include a requirement that the disclosure to produce records be in writing, and it not be simply someone asking to provide the documents. It's important to follow these guidelines and to keep track of how you follow these guidelines in the case of every patient and every employee. And the reason for that is that every patient, every employee has the ability under the statute to request that you provide them not only with the personal information that you have, but with a copy and a record of how you've used that personal information over the past time that you've been in possession and control of it. If you don't have a complete record of how that information has been used, you again would be open to sanctions under the statute. So it's important that you keep a clear and proper record of the information that you have that's personal in nature and how that information has been used. Now, from a practical standpoint, if your filing is up to date and you keep good files, you'll have met these requirements. You'll have a copy of any request for disclosure of the information in your file. You'll have a copy of the information that you actually sent out. So it'll be very easy for you to respond to that request. If, however, your filing practices frankly aren't adequate, if they're not up to snuff, this will be a challenge for you. And it hopefully will be that much more of an incentive for you to correct those practices now. If you get a request for the disclosure of personal information from someone, and they write and advise you that the personal information you have on them is incorrect, and they want you to correct it, you have two options. One, correct it, or two, don't. If you choose to correct it, you should then send out a follow-up to any people that you have previously disclosed that information to, correcting the information that you had prior disclosed. If you decide not to correct the personal information for any reason, and there may be any number of reasons why you choose not to, you should make a note in your file very clearly indicating that the request was made and clearly indicating the reasons that you have for not making the correction. It's important, again, that good file keeping practices and guidelines be followed in these circumstances, because you will, again, assuredly be contacted by the Privacy Commissioner in the event that you refuse to make the correction that's been requested. Those are the comments that I have with respect to the most basic elements of the protection of personal privacy and under the PIPA. And again, I would encourage you, if you have more questions, go to the Office of the Privacy Commissioner on their website, look for this guide. If you have any questions still after consulting the guide, please contact the association office or your own legal advice. Thank you very much.